Supreme Court of Pakistan, Article 22, Identification Parade, How Conducted Guidelines, 2025 SCMR 50. Article 22, Identification Parade, Principle and Scope. Identification Parade is one of the methods of proof contemplated under Section 22 of Qanun-e-Shahadat. It must be carefully conducted in order to achieve its main object, i.e., enable witness to properly identify a person involved in a crime, to exclude the possibility of a witness simply confirming a faint collection and impression. The process has to be carried out having regard to the exigency each case in any manner that is fair, does not indicate any collusiveness. It's merely corroborative piece of evidence, and holding test identification period is not mandatory if testimony, the witness question, identify the accused, inspires confidence, and witness are consistent in all material particularly, and there is nothing in the evidence to suggest the latter and dispose the falsely, then in such eventuality not conducting a test identification period is not a fatal to the prosecution's case. Omission of salient features in crime report is not necessary a ground to discard a test identification period. Test identification period is therefore not required when the victim had identified the accused and his statement has been found reliable. In the present case, the test identification proceedings were fraught with the serious infirmities and therefore could not be relied upon for handling down. The conviction proceedings were conducted and supervised by a judicial magistrate first class who had admitted his testimony that features of the petitioner and 8 dummies were not recorded in the report. It was likely that the 2 police officials who had arrived at the crime scene after the incident had taken place could have been identified. The accused who had fired at the deceased, none of the witnesses had attributed a specific role to the petitioner in the facts and circumstances of the case. It could not be ruled out the witnesses of the test identification proceedings may have seen the petitioner in his. It also appeared from the deposition of the judicial magistrate who had supervised and conducted the test identification proceeding that he was not familiar and guidelines and principles enunciated by the Supreme Court regarding the test identification proceedings. Probability evidentiary value of the test identification proceedings were definitely questionable and thus could not have been relied upon for the purpose of handing down the conviction. Petition was granted an appeal and allowed. The impugned judgment of the High Court was set aside and the appellant was extended to the benefit of doubt. For more vlogs on law, please watch my videos and subscribe my channel, please.